5 seconds to go. Start. Still, it appears that he was accepted by the family after he had returned after serving the sentence about 4 to 5 years prior to the incident. It appears that thereafter also his act of raising suspicion over the character of deceased did not stop, and PW3 Rohini says that it was regular for the appellant and the deceased to raise quarrel on that point. When about 12 external injuries have been noted on the dead body, it can be certainly said that the appellant had intention to commit murder, and it was not the act of spur of moment. The testimony of eyewitness is certainly reliable. As regards the defense witness, it is to be noted that said DW1 Abba has admitted in his cross-examination that a labor can complete work assigned to him within half an hour, and the distance between the house of the accused and his house is only 1000 feet. According to him, his land is Jirayat land and he can take crop only during rainy season. He used to look after his cattle himself, and according to him, he has also engaged other persons. He used to sell the milk of the cattle from his house itself. He is having 8 she buffaloes. Therefore, what kind of work he used to give to accused is not clarified by him. Which work he had assigned the accused on that day is also not clarified by him, and therefore mere utterance of single sentence will not be sufficient to prove the alibi. There is no merit in the present appeal, it deserves to be dismissed. The first and foremost fact that is required to be considered is as to whether the death is homicidal or not. In order to prove that the death is homicidal, the prosecution is relying upon the oral evidence as well as documentary evidence in the form of inquest Panchanama and PM report. The inquest Panchanama Exhibit 14 comes first, and even as per the prosecution story, the inquest Panchanama was carried out in Civil Hospital Dhule. Now objection is raised that it is not as per the requirement of section 174 of Code of Criminal Procedure. The answer to the question could have been very well given by PW11 investigating officer. He could have told the reason as to why it was executed in the post-mortem room and not at the spot. When there was an opportunity available to the accused to extract this reason, no question has been put to him. Under such circumstance, at the appellate stage, for the first time, such point cannot be allowed to be raised. If the defense had serious objection about the procedure that was adopted for executing a Panchanama, then necessary questions should be asked to the concerned person. This fact can also be taken from another angle. Merely because the inquest Panchanama has been carried out in the post-mortem room, what prejudice has been caused to the accused has not been shown by the accused, and therefore it cannot be taken as such lacunae which goes to the root of the case, raising doubt over the prosecution story. Stop.